This program is brought to you by Emory University.
Good afternoon. My name is Rebecca Salmon, and I run the Access to Law Foundation in Norcross. I'm previously from Catholic Charities, so you know that I was trained upright. I am so pleased and honored to be here today with Professor Price, Jessica Damon, and Doris Good. We've invited Immigration Judge Madeline Garcia, however, she's unable to attend today. So I do want to take a moment and let everyone introduce themselves. Professor Price, if you'd start with you.
Sure. My name is Polly Price. I'm on the faculty here at Emory Law School. Among the courses that I teach immigration law. And in terms of recent experience, I've been working with the U.S.-Mexico Border Health Commission with cross-border issues.
My name is Jessica Damon. I'm a staff attorney at the Latin American Association here in Atlanta. Previously, I was also at Catholic Charities Atlanta working with their Immigrant Children's Justice Project. And I also work with unaccompanied minors in my current work with the Latin American Association, representing them in removal defense and in state court juvenile proceedings.
And I am Doris Good. I am a National Child Welfare Law Specialist. I am a solo practitioner. I practice almost always in juvenile court. I represent parents and children in dependency and delinquency actions. And most of my guardian ad litem child attorney work in juvenile court is with children who are being sought to be found dependent in order to qualify for SIJS status.
Well, again, thank you all for being here. And the presentation that we're going to give, mostly so that you don't have to only look at us, is entitled Special Immigrant Juvenile Status. And although we do want to teach you basically about that status, because it's a very clear intersection where the immigration law and the federal demands intersect with state law in 50 different states and several different ways. There's also obviously many other issues of family law and state law where immigration and the court in the state level intersect. But this is one place that I feel that we're all very comfortable in discussing so that we can pinpoint those intersections. So as you can see, special immigrant juvenile status is basically, it's for the protection of children. It's for children who maybe just recently crossed the border. I'm sure everyone's heard of the recent surge of children. I believe our most recent number is somewhere around 89,000. Central American youth have fled their homeland and come into the United States. Despite some of what you may have heard, they're not all here in Georgia. We only have maybe around 1,100 at the last count here in Georgia, but they are actually and obviously hitting our courts. The most important thing for this relief is, you know, I've heard other folks talk about anchor relief or an anchor baby situation. That's not the case. This is an individual form of relief. So Jessica, could you talk a little bit about what the requirements are for this particular relief?
Sure. So as Rebecca said, SIJ and a child who's eligible for SIJ, it really can vary state to state. And it's something that I think Rebecca and I both see when children come into our offices for an immigration consultation, because the Atlanta Immigration Court serves not just Georgia, it serves Alabama and even parts of South Carolina. And so to adequately and completely advise a child as to whether he or she might be eligible for this form of relief, it really requires you to either be competent on the state dependency and juvenile laws in those states, or to know someone who you can ask questions. And I think that's kind of a theme picking up from the previous panel is, you know, I'm licensed here in Georgia. I'm somewhat familiar with Alabama juvenile law, but I do have an attorney that I call frequently and bother and email to ask questions about that so that I can properly advise the child as to whether he or she meets the dependency guidelines under that state law. But to go back to the basic requirements, you need to be found dependent upon a juvenile court, and how that looks can vary widely based on what state you're in, and you might have very different outcomes based on what state you're in. There are some states that allow for one-parent SIJ status, and that's where you might be living with a mom or a dad, but you can still be found dependent, or you might still be eligible based on other factors. Here in Georgia, we have two-parent SIJ. You have to not reside with either one of your parents and be found dependent under juvenile law. And that can meet a variety of definitions, and that's where you get creative as an attorney to tell your child's story and show how they meet that dependency definition under state law. It can be in the form of abandonment. It can be because the child is here without a parent or legal guardian in the state. It can be that the child was subject to abuse, neglect. The child maybe witnessed domestic violence in the home country. That's something that the new juvenile code here in Georgia includes under the definition of neglect, and that's a very common fact pattern that we see. And then beyond that, you have to have the state court find that reunification with one or both of your parents is not viable, and that it's not in the child's best interest to be returned to their home country. So those are the core requirements that you're asking a state court to find.
So I did pull out a few of the ethical issues that immediately just with the base requirements. So maybe, Doris, you could talk about what are some ethical issues, because as you can imagine, these children don't typically pack a bag and their birth certificate and their important documents before they hop on a plane and get off in Atlanta. They're literally fleeing their country with nothing more than the clothes on their back. So Doris, have you seen instances where you have children coming before the juvenile court and you have to prove their age?
Yeah, I mean, I think the biggest ethical issue is whether or not it is the age and whether you can obtain a birth certificate. We have been able to do that in numerous ways. One, by going through the consulate of the country that they've come from. Sometimes we've had to file in the Superior Court for the state to create a birth certificate for the child, and then ultimately is based upon if the child's verbal, the child's understanding of their date of birth. I actually have 2 cases currently where that's at issue. We have 2 different dates of birth and no one can determine which date it is. And of course that matters because in order for a child to be found dependent, they have to be under the age of 18. So the ethical concerns are of judges, and really judges, because not all of these cases have a opposing party like the department, is whether or not this child is ultimately under the age of 18, or is it just a child they're trying to run through to get immigration status so that they can live here legally.
Hey, Professor Price, let's talk about that, because Doris said that they have to be under 18 here in Georgia, and that's obviously a very Georgia-specific restriction from our code, but they can be different ages in different states under the federal law, right?
Yeah, that's correct. And so, there's really no substitute for, I think, getting counsel in those states to advise on those specific matters.
How do you feel, though, as far as if we're talking about the ethical issues, is it ethical to have a federal relief that is really dependent on where you land?
No.
Yes.
No, it isn't. But it also raises another issue, I think, with respect to attorney representation. And with attorneys that are working in immigration law and the family law areas together, I can't think of an area that's more potentially fraught with ethical dilemmas and which there is less guidance for those. And one of those would be the extent to which blatant forum shopping is a requirement of zealous representation. And in an asylum context, it matters very much which state you're in. So I could imagine very many situations in which if there's another relative that the child could live with in a state that has perhaps more favorable laws with respect to ages, and then the question is, how do you take other family circumstances into account?
It's a struggle every day. One other sorry, go ahead.
I was going to say one of the biggest ethical issues that children's attorneys have is that, let's say, for example, the birth certificate is telling us that the child is 15, but your child says, I'm 17. I was born this year, not the year that's on there. So then what do you do about whether or not you need to inform the court, candor towards the tribunal, towards other parties, your ethical obligation to your client, because your job is to zealously represent what your client wants, which is, to be able to have this status. So I think that's a huge one for a lot of people.
And Jessica, what happens if you had a great attorney like Doris who, was able to get some testimony on the record that the judge felt comfortable ruling that the child testified to their birth date in their home country, but you still don't have that birth certificate because you maybe weren't able to get the consulate to agree with issuing a minor child birth certificate without a parent? How do you deal with that at USCIS? Because now there's another level.
Yeah, and so, let's say that we can get the juvenile judge to find that the child's date of birth is whatever it might be, and it makes that child eligible to be found dependent, and you get your qualifying court order, you still have the hurdle of then going to immigration, whether it's court or whether it's USCIS, depending where the case is being adjudicated, and meeting federal regulations and federal documentary evidence guidelines. And those are pretty clear that you need to have some sort of government-issued declaration of the child's date of birth. And that can be very difficult. Like Rebecca said, these children come with just the clothes on their back. So we get very creative, and it's important to then try to make the best kinds of relationships you possibly can with consulates and with consular officials. The Latin American Association is lucky to be in the same building as the Honduran and Guatemalan consulates, and they do have laws about not being able to issue passports to children of certain ages without parental consent, and a lot of these kids are fleeing parents for specific reasons. There's not a great relationship there. Maybe parents are dead because of violence. And while they might not be able to issue passports, we have had some luck in getting letters from the consulate explaining this is why we can't get them a passport, but this is the child represented X date of birth, that sort of thing. So you have to be creative, but it is a hurdle that you come up against.
So one other thing then, let's talk about the deprivation, which is now, deprivation, which is now dependency in Georgia under our new code. There's some very clear new definitions under the new code as it relates to abuse, neglect, and abandonment, but as you know, it's gonna make our job easier at USCIS if we get the state judge to make the state rulings, but also include a reference to a federal law. Have you had any pushback with that?
I can say I have, and I know that Rebecca does the same. We're located here in Atlanta, but there is a real dearth of services in general for the immigrant community in Georgia, in particular for children with this sort of representation. If you go to Middle Georgia or South Georgia, there's no one really, and especially no low-cost, very knowledgeable and experienced providers of these sorts of services. So, it's not unusual for me to be driving 4 hours down to Valdosta one way and 4 hours back up here to represent a child in state court. And many of these judges, in my experience at least practicing, they're just not familiar with this particular benefit, and they get a bit nervous about their boundaries as juvenile judges to make certain findings that are for an immigration benefit. And that's where I think a really good representation is the key to success for that particular child, because I've found that if you just explain, the regulations say that a juvenile court has to make these determinations because that's their area of expertise. You're not overstepping your boundaries. In fact, you're fulfilling a statutory right that you have as a juvenile judge to make these findings to benefit a child who is dependent in your jurisdiction. In many, many cases, that's enough to assuage many judges' fears. And sometimes, I'll even offer to craft the order in a certain way where the judge wants to make it very clear that, I'm finding that reunification is not viable because of this, and this that you presented, and that's enough for them to feel better about it. So it's just a lot of talking and being knowledgeable and prepared to explain to the judge why you're asking for this language that ordinarily they would not put in a dependency adjudicatory order.
And Professor Price, I see you wanting to talk, and I hope that what you want to talk about talks about federalism.
Yes. Yes. It is. But what I wanted to say first was that I think that the Georgia Bar is trying to train judges more in this area and also other immigration matters that relate to family law or that they're going to encounter in their courts. And so, I applaud that effort, and I think more is needed because I agree that education is really it is a complicated area, and just to be able to explain to someone's comfort level, especially a judge, their comfort level, what's going on is important.
Absolutely.
I think that in the counties that I practice in, most of the times you've got a private petitioner who's the family member or fictive kin that we call in independency courts who have their own attorney. And then you have me who's the child's attorney. In that case, I don't have any judges really don't care because I draft the order and they sign it. It's the cases where the department is involved. This child was found dependent. Our laws just changed, so we're still getting used to the new words.
And could you define department real quick? I just want to make sure everyone knows.
The department is the Department of Family and Children's Services, who is legally obligated to remove children who are allegedly abused or neglected or abandoned. A lot of the times what I come up against is when the department is in the case, I represent the child, the parents have attorneys and the parents are parents who the court has found the children cannot be reunified with, then that's the time that we want the order to start indicating the SIJS language. And a lot of the times I get kickback from the department's attorneys, which are the special assistant attorney generals, who don't want this federal language in there and don't want this as, you know, a road to immigration per se. So that's where I've had the hardest problem, is having, you know, the order reviewed and then kicking it back to add that language and them objecting and then having to have the judge determine it and things like that.
Do you think, let's talk about that as far as the department just in particular. What do you feel are the ethical obligations between the department's attorney and the child's attorney then to negotiate that if the mandate for the service is to provide for that child equal or at least as equal for stability as the parent should have, and they fail to address the future, which is the basis of stability?
I think that on both, I think the department who is in words tasked with providing the best interest of the child. Now, whether that occurs in reality or not, and how political and other stances come into it is a different story. But yes, if you're the department and you have custody of a child and it's in their best interest to remain in the United States, then I think ethically you must negotiate that with not just the child attorney, but the court and the parents, because that's what the department is supposedly tasked with. I think the problem comes in with the department is they also believe in some ways they're the upholder of the law, and that as an attorney general they shouldn't be circumventing immigration laws because they aren't familiar with SIJS and how it works, and Anchor Baby is something we hear all the time with the department. But you know, the department is required under their own policies to immediately contact the consulate of any country through the Vienna Convention that this child is in their care. So the department has other ethical obligations to the child's home country that we don't see happening all the time. Like, you know, I'll get a case and I'm like, well, is the consulate notified? No. So those are things that are required. So the department has a lot of ethical obligations that aren't necessarily being done. And in some counties, they're great. I have one county that always does it, is always putting the SIJS language in, so.
Just generally, and I want it to be a real quick answer because my next question is even better. So just generally, how long, if a child is in a dependency proceeding from start, and I mean start filing that initial petition and package to finish final order, what would you say is a reasonable and average timeline? And let's take the service out of it. Let's say the department's not involved, and let's just say it's a private.
Well, I can tell you under Georgia law, they have a limitation. So from the time that I file that dependency petition as the attorney for the petitioner, if the child is not in state custody, which in these private cases they never are, they have up to 60 days. That's 60 calendar days to set a hearing. So we should at least have the hearing within that timeline. And most often, the courts are fine doing adjudicatory and dispositional hearings all in one with these private cases. Usually it is a bifurcated process where the child is adjudicated dependent, and then later you have a dispositional hearing, at which time, if they're in department care, they might have like a case plan set up, and so sort of steps moving forward, any sort of review hearing set. But because these are private cases where the state is not involved and the department is not taking the child into custody, most often we'll have the adjudicatory and dispositional hearing all in one, and most often, if everything goes well, I should be able to get an order signed that day or shortly thereafter. That's best case scenario, but that's not always what we see, and I think Doris can talk a little bit more about that.
I don't know where she's practicing.
So wait a minute, so keep this in perspective. So we're starting with 60 days being the best case. What's the real case?
And to tell you the truth, the real case isn't bad. It can be between, most of my cases are resolved within 3 to 6 months if it's a private petitioner case. The issues come in with one attorney scheduling, and like I have one right now that's had to be continued twice because the petitioner's attorney is in immigration court, which takes precedent over juvenile court. So the legal rules of, conflicts for attorneys is, has us in juvenile unless it's a termination at the very bottom rung of the stack. And the other issue is how soon the court appoints the child attorney to do the investigation to, make sure that this is the decision that the court wants to make. Also, the code, and I think you said it perfectly, Jessica, the code says that the hearing has to be set in 60 days, which means technically the judge could set it in 60 days and then continue it at their discretion. Now, we also have a code section that is very, very specific now about the reason for continuances in juvenile court, because we are dealing with children who are out of their homes or in custody or with a relative, but it's, I would say, 3 to 6 months. And I tend to take about 3 months with my investigations, so some of that really falls on me personally. Like Jessica, I have a lot of national contacts, and through them I have international contacts. So I always want to make sure that I'm finding someone that knows about where this child came from to be able to state, listen, this was why this child can't come back.
Wait a minute, you're doing thorough investigations?
I know.
Oh, wow.
I actually meet with
Ethical.
my client.
I wish Doris
Fantastic.
could always be our guardian ad litem.
And we like to hear that, but wait a minute, my head is about to burst, because we're now hearing, 60 best case, maybe 3 to 6 months or 4 months. But Jessica, what happens when you're in immigration court and that child, they came to you after their first immigration hearing? When's their next immigration hearing?
So I think that the biggest problem confronting us with the juvenile cases, and maybe the biggest challenge to due process generally that we're seeing right now, are the so-called rocket dockets that we've seen implemented here in the Atlanta Immigration Court. So many of you might be familiar with the fact that there has been this surge that Rebecca alluded to, and in response to this surge, immigration courts have said that these unaccompanied minor cases are their priority, and they have new timelines for which a child has to have their first master calendar hearing before the immigration court, which to me, in theory itself, is not so bad, to make sure that a child's going into immigration court for their first appearance quickly.
Which is 21 days from the time that child's feet hit Georgia, and the government files that notice to appear, which, for lack of a better term, it's like their arraignment, charging document. They have to have a hearing, their first hearing with the immigration judge within 21 days. Again, reasonable.
Reasonable. And, a lot of time, and previously before the surge and before UACs became a priority, we would even have meetings with the Atlanta Immigration Court to ask that they get that master calendar hearing scheduled quicker, because previously sometimes a kid wouldn't have their first hearing for a year and a half or 2 years. And many children, they don't come seeking our help until before that first master calendar hearing. They think there's nothing to do until court is set. And in that meantime, they're aging, and they're getting closer and closer to potentially aging out of remedies. And so before, we were wanting kids to be seen quicker so that the impetus of going and seeking counsel was put upon them faster. Now these children are going into immigration court very, very quickly, and 3 different judges here locally are hearing these cases. 2 of those 3 judges will sometimes give kids 9 days continuance, 14 days continuance to come back with an attorney. And
I want you to take a deep breath, because I want everybody out there go, oh my God, right?
For a child.
A child,
Yeah.
unrepresented.
Unrepresented. And Rebecca, myself, and Catholic Charities, we're the 3 nonprofits serving this Atlanta Immigration Court. I'm the one UAC attorney at the Latin American Association. Rebecca is running her show. There are, I think, 2 or 3 attorneys at Catholic Charities that will see these cases. So we're talking 5 low bono or pro bono attorneys. I don't have availability until next year to see these children.
And a minute ago, you said you were driving 4 hours to do a hearing, and that means you drive 4 hours back. That's a whole day of work that you're gone on one kid.
One kid.
And how many counties in Georgia?
120.
159. Together, I'm positive we've been on all of them.
And so, a child might come in desperate to see me, and I have to tell them I'm sorry because I've got all these kids scheduled to see me, a waiting list this long. I can't let you jump the line, and they're going to another master calendar hearing unrepresented. And the things that are happening to these children unrepresented can be kind of shocking. I saw one child. I had one of our law student interns sit in, and she reported about one child before these rocket dockets who was 14 years old, unrepresented, and made to plead to his notice to appear without an attorney present. It was just Department of Homeland Security and the judge asking him to plead to this complicated immigration document about whether or not he's admissible to be here. And then ultimately he was ordered removed that day because the judge determined he probably didn't have any relief. And this is an unrepresented 14-year-old child in a country, in proceedings, in a language he doesn't speak.
And let's back up just a minute before we get into the good stuff. These are kids, uneducated, naive, ignorant in every sense of the word, in a very formal, scary setting, in a room of maybe 80 strangers, with this person up on a bench, oftentimes, speaking very forcefully at them, yelling at them, why 9 days ago when I told you to go get a lawyer, you didn't do it, forgiving the fact that perhaps they don't have any money. Perhaps they couldn't articulate because their sponsor is also undocumented, so couldn't come into that federal building that's full of immigration officers. I mean, it's extremely complicated. And even yesterday I was there where 4 pro se people had come back for their second master calendar in the course of 14 days. It was extremely generous. And they had a piece of paper because at least all the nonprofits in Georgia talk, and we now said, well, at least we can give them a date for an appointment, a consultation, which may be 45 days out. We can send them to court with that saying, I can't even see you to hear your case because I have no available consultations until December 15th. So I saw the children yesterday there showing this piece of paper, and the judge, I like to think that it was because I was there. Who knows? But I saw the judge think a minute as whether or not they're going to give that second continuance. And the judge very harshly told that child, fine, I will set your hearing then, your appointment with Catholic Charities, this happened to be, is the 11th of December. You'll be back here the 12th. So now Catholic Charities has to meet the client, assess the client, and sign the client before they come back on the 12th, because that kid has to bring Catholic Charities back on the 12th, or another attorney. So, I mean, the complications of the due process simply happening is overwhelming for an adult, much less a child.
One thing I wanted to say, piggybacking off of Jessica talking about the rocket dockets, which I don't want to add to it, but there can be a very good argument made when you have these rocket dockets. In juvenile court, it states if the child is not detained, the hearing should be set within 60 days. However, there is a good argument to be made that the child is actually detained, because what not being detained means is that the child is in the custody of the respondents. So if the relative is the petitioner and the child's living with him and the parents are in some other place or they're even here, then the child is actually detained because he's not living with his parents who are the respondents. If that is the case, then the hearing has to be set within 10 days, and that right cannot be waived except for by the parents. So if the parents don't appear, it still has to be set within 10 days. So it's still the kind of set language versus the heard language, but in those cases, there's a stronger argument that it has to be heard within 10 days. And there's a good argument that this child is considered detained under the code because he's not with she or he's not with his biological parents.
And that's fascinating, but Jessica, if you got a hearing in 10 days, could you meet the requirements of Georgia law to get a final order, which is our ultimate goal, in 10 days?
And that's where the complications come, and usually I'm fine with it within 60 days because it's upon me to also serve notice of the hearing upon the parents, which can be quite a feat because most of the time the parents are living abroad in a foreign country in very remote areas without access to things like fax machines and computers, and it's hard to, they don't have necessarily physical addresses like we have here in the United States where I can FedEx or certify mail something and be guaranteed that they'll receive it. So there's always that complication or wrinkle as well. Another wrinkle is a lot of times my children, they don't know where their parents are. I recently had a case where the child was born in Guatemala. His mother was a Mexican citizen, abandoned him at birth because he had certain, physical, like birth defects. He was born with birth defects and she didn't want to take care of him and so abandoned him at birth pretty much. He has no idea where mom is. She could be in Mexico where she's a citizen. She could still be living in Guatemala. She could be anywhere. And so in that case, we have to actually publish service, and there's certain legal requirements for that where the service has to run for a certain amount of time. And many judges often want that to be published locally and internationally too. And so I'm working with the consulates to see how do I serve parents in Mexico or in Guatemala. And, so that places an extra wrinkle or burden upon me as the attorney in these sorts of cases.
Everyone's going to run out and start representing children.
I know.
No, we're making it sound so
And we don't
exciting,
want you to think it's not exciting or rewarding. It really is, but it's hard. So that's why we want you to have contacts and training and mentors. Let's go back to state just for a second, though, because there's a great case of, in the interest of JJXC, Jessica's amazingly attuned to this. Tell us about this case.
So this is my case. This was a child who was abused and abandoned by parents abroad, and we brought a private dependency. At that time, it was called deprivation petition before Gwinnett County Juvenile Court, and he was living with brother and sister-in-law, and they were great caretakers, employed. His brother's an IT worker. He does, that computer repair that you freak out that you need in your office, and the sister-in-law worked in a store, and they petitioned for, the finding of deprivation at that time in custody of the child and the additional findings for special immigrant juvenile status. We had several hearings with this particular judge because he was very reluctant to put in the special immigrant juvenile status language. He agreed the child was deprived under state code. He agreed that custody should be with brother and sister-in-law, but where he was very hesitant was to put that extra language that reunification with one or both parents was not viable and that it was not in his best interest to return home. And despite all of my persuasiveness at the trial level, he just would not put that language in. Interestingly enough, when I asked that he would put his reasons to deny that on the record, he also declined. He said he would not put his reasonings for the denial of this request on the record. So the record was silent as to why he denied that. He just found the child deprived and gave custody to brother. So we had to appeal that up to the Georgia Court of Appeals, and happily they reversed and remanded and said, by denying that, you're basically denying this child a substantive right to immigration status, and you have to at least consider these factors. And maybe if the judge finds that I didn't meet my evidentiary burden, because I do have to prove this by clear and convincing evidence, then the judge can deny it, but they at least have to put the reasons on the record. But absent any sort of reasons, absent, my failure to prove my evidentiary burden, they have to consider these findings and give them if appropriate.
I want everyone to put that in your toolbox. That's called the law, and we need to use that. And Jessica, were you able to do that in the 14 days before you had to get back to immigration court?
This child, happily the child was 15 at the time that the case was first heard in juvenile court. By the time it went up to the Court of Appeals and was reversed and remanded back down, and then we had another hearing, he was 17 and a half, almost 18 years old. And so happily at that time, this was pre-rocket docket, this was pre-surge political considerations. Happily I had a judge who is probably one of our best juvenile judges that we have at the Atlanta Immigration Court, and she was very generous with continuing it out as long as I proved it was still pending with the Court of Appeals. So happily I had that luxury. In today's environment, I think this child probably would have had to take a removal order, or that would have been the outcome because it was pending with the Court of Appeals for a while.
But wait a minute, a removal order, doesn't that mean now you're excluded from applying for a benefit by a different court? It's kind of contrary to the same case we just talked about. So do I see future litigation?
I think there's going to be a lot of litigation coming out of this whole situation that we're in.
Good. Can you talk a little bit too then about, just one practice pointer there then, obviously read the law, know the law, and by that I mean the juvenile law. If you're going to go into juvenile court, it's a fascinating read. Read the code. It's amazing what you find in there. Read the case law and know what you're doing as far as the elements that you have to prove by clear and convincing standards, and make your appeal record. Vital. If it's not on the record or you didn't ask for it, you cannot appeal it. So be prepared.
Yeah, or at the very least, call us about the juvenile law.
Call somebody who knows.
Because I call Rebecca when I need to know about immigration law, because I don't have time to read that big, huge book. Code, something that you use in court. But, we have a lot of folks in juvenile court who are constantly available to answer questions, because we also know that we'll need you folks in immigration at some point in our lives.
And even as Juan, I'm sure everyone here listened to John Sperling earlier, I mean, we have developed into, pseudo experts in our field. I call Jessica at least once a week. She calls me. Don't be afraid to ask for help. It's out there if you're willing. And on that note, because this is my personal peeve, Jessica, how do you feel about someone, brand new attorney, just out of law school, just got their bar results, congratulations, who calls you up and says, will you just give me all your templates on how you do this?
And I have to say, this is something that we're seeing more and more with the surge because, the nonprofits are so overwhelmed and these kids are being told, come back with an attorney or I'll deport you. So they will go to, and this is an opportunity for new practitioners to try this area of law, and I don't want to dissuade anyone from trying it. It's certainly very rewarding. However, if you call me and just say, can you send me all of your templates? Or you call me, can you send me all your templates? I have this kid who's living with mom, but reunification with dad's not viable. This tells me a lot of things. I mean, it tells me you haven't read Georgia juvenile law. You might have just read the immigration part where it says reunification with one or both parents is not viable, and you stopped right there, and you said, okay, well, one parent, it's not viable, so let's move forward. And it makes me hesitant to help you because I'm worried that you're not going to put in the good effort to represent the client appropriately, and that you're also going to muddy the waters for every other child who goes before that juvenile court asking for SIJ status. Rebecca and I have advocated and worked for several years in this area to educate juvenile judges, and we've made some big inroads in a lot of counties. I think previously Gwinnett County was a very difficult court to get these orders out of, and now it's almost like clockwork. You go in, you request it, the judges will sign it. But that's after years of advocacy. That's after this Court of Appeals decision. It's after us.
And when you say request it and sign it, she doesn't mean request it and sign it. She means request it properly with your pleadings, do your whole hearing, do all of your evidence, put clear and convincing evidence in the record, then they sign it.
Mm-hmm. and that I think that makes a very good point in, the juvenile court is that the metro judges in juvenile court are hesitant to do this, especially when you get into those kind of northern areas of the metro county. Because of the judge's personal stance on immigration. I mean, ultimately.
We're in a hot political bed right here in the Bible Belt.
It's very political, and so I can only imagine what rural folks have to go through on this, because if our metro judges are hesitant, we got a lot of work to do in this state. So you've got to be very mindful of that, and I think the best argument to make to our juvenile judges, and I sit pro tem in Fulton Juvenile Court, is that really showing how horrific this child's circumstances are if he were returned to his home country. Because that's where you're going to get us, is that, the fact that this child was living in, I have one that had an outhouse, like a true outhouse, and, 8 people in one room. These are judges who will deprive children because they don't have a bed, even though they have a roof over their head and food in their belly. These are judges who won't send children back home because the parents have 2 bedroom and all 4 children are going to sleep in 1 bedroom. Okay, so really relate it to what the judge is going to understand and connect to when it comes to the circumstances of the child returning. So most of my investigations are focused on that issue more than anything else.
But what do you say to the judge that says, well, but they're not American, they're not even Guanetians. That's normal in Guatemala. Because I know you've heard it.
We're recording, right? You're on. I mean, I had one of my children's parental rights terminated because the parents didn't speak English, and so apparently, if you don't speak English, you can't parent.
And let me phrase that, because I think everybody's going, "What? You're a bad person."
Yeah,
she didn't ask for that. She received that.
Yeah, in a courthouse where all of the signs are in Spanish and English. Okay. But it was just so appalling, and I think that you have to turn it back to, the fact that in this courthouse, every child who comes in it is is, equally protected under our laws.
And that's what I try to do. There are many times where there's a lot of emotion in what we do, but this is a time where I just turn it back and I say, Your Honor, the Juvenile Code is written to protect children within your jurisdiction. As concerned I am outside this courtroom with all the kids who are here, today I'm only concerned about this one right here in this courtroom before Your Honor. And I want you to focus on how it's going to affect this child. And let's pretend that we're not going to, that the option isn't to send him back to Guatemala. Let's pretend that this child came from Cobb County, and your option here in Gwinnett then is to send him back to Cobb. Would you send him to a house in Cobb that had an outhouse and 5 kids were in one room? And then, I really don't think they're bad people. I think that when you say it that way and you take the emotion out and you turn it back on the statute and the requirements and the law, it gives them a chance to stop and think. And, as with everything today and us here learning today, knowledge is power. So take the opportunity to educate your judges about why you're asking for these things and be transparent, I think is important.
And just kind of touching on what Rebecca and Doris have both pointed on, and just to speak to my own personal experience, ironically enough, I find sometimes in the most rural areas of Georgia, judges are most cognizant of their limitations and their duties to the child and what their role is as a juvenile judge. So often, for example, I went up to Rome, Georgia on a particularly horrible case where I filed the dependency petition 2 weeks before the child was going to turn 18, and it was a Hail Mary. They did not have to give me a hearing date under the code. I begged and pled, and I did get a hearing date. And this judge even said on the record, I might have discomfort with the fact that so many children are coming here, but that's not the children's fault. That's something to do with the home country and the parenting situation and the home life. And my duty right now is to think of how I can help this child. She's in my jurisdiction because she lives in my county, and does she meet the legal requirements? And so, always turn it back to
and keep
that.
it very narrow.
Yes, to this child, not all 60,000 children.
Well, and then juvenile judges like to be played the God complex because, for so long, and I don't think this way, but for so long, we've been considered kiddie court. When in fact we're dealing with the most important issues besides probably getting the death penalty, which is the right to your child. And so judges, I like to say, well, Your Honor, this child is before you. This is your decision. This is your jurisdiction. We're going to do what you want to do because this is and they love it. They're like, yeah. Yeah.
You can go home tonight feeling like you made a difference.
Yeah, it's my court. Who cares about Guatemala? My court.
I want to just toss in another issue here with respect to children and their representation. So, there are so many mixed, blended families in the United States, parts of them. Some, American citizen children, siblings can differ. And with respect to their representation, at least on the immigration law side, you're an immigration attorney, you're either looking for benefits or you're in a defensive position. Often you're, if not formally, at least informally representing a family unit. And that has got to pose ethical issues and dilemmas for the person in terms of what's in the best interest of the child, or what's said differently, what's in the best interest of one parent may not at all be in the best interest of the child, and then what one would do in those situations.
For me, it would be more as what the petitioner is interest, because in Georgia, parents are entitled to representation if they're indigent. So if the parents are involved, then they are entitled. And I think where that comes up the most is when you do have, I have a child of a 13-year-old from Guatemala. I represent him, which is a U.S. citizen, and his mother and their siblings, their mother wanted them returned back to them in Guatemala. And it was really difficult for me because kids wanted to go back to mom in Guatemala. They did a home evaluation, but then my U.S. citizen child is going back to Guatemala, but I wasn't. She was actually a very good mother. I think that's, partly culturally in that, children I mean, I hate to say children at 13, but going back 100 years ago, you wouldn't have been considered a child if you had a baby. But so there was that concerns, and then the concerns is if the child is with a petitioner who the circumstances may not be good. And that's where I think it becomes very difficult is, if you learn of abuse or other things going on in the petitioner's home or drug use or something like that. So do I leave them in the petitioner's home or do I recommend that they go back to the parent who, may come with horrific, and I think ultimately for me, my ethical struggle always comes down to the lesser of two evils.
And with respect to parents, so for example, the ABA has been long concerned with the idea that one parent should be able to use undocumented status against another, either in a custody dispute or other, and to the extent that there might be some circumstances in which doing so is more beneficial to the child, and yet if you believe the ethical obligation is not to make the undocumented status part of a domestic court proceeding.
I think the biggest first question, at least for me, and I don't know if it is for y'all, but my very first question is, do I want to trade family in that connection for papers? And for me, never. So then I take that immigration question and I put it in the box with all those other aspects of the case and I weigh them as one of the factors, not the factor. And I think that I've also been able to minimize the issues with judges in that way. Just minimizing that obviously immigration status is one factor, but it's not the factor. And I just think that that's important whether you're talking about, returning a non-citizen child to their home, sending a citizen child, because you're not returning, you're sending a U.S. citizen child who's entitled to the protections of this country, the education of this country, outside of this country. And then what's going to happen when they're 18 and maybe want to come back? Are they going to be, at the base level, education and job ready at 18 to rejoin the American culture? I mean, there's so many factors. So, go ahead.
I often pose the question, not just on these cases, but others, when we see the department removing kids from from extended hotels. Like, would I rather be with my mom in an extended hotel at age 12 or be with the department in foster care with strangers? And with these children, I think about that. My mother immigrated here from the Ukraine in the 50s, and I think, well, would I rather live under Stalin with my mom, or would I want to be in the United States? And so I think sometimes you really do have to put yourself in the eyes of the child and look at that when there are similar circumstances and when there are questions that, obviously not in cases where the child was horrifically abused with the parents or is running from civil strife or civil wars or wars for that matter. But I think when you have circumstances where it could be either way, children, research-wise, always do better with their biological parents. So sometimes that's hard to overcome if the circumstances aren't so drastic.
And I think that I'm going to skip ahead here just a little bit because I want to make sure we have time for questions in case there are any. Kids are different. Kids are different clients. And now, we've talked about the complicated intersection of several different bases of law and several different standards of law and many, many actors involved in this one case. And then the timelines and all that. So let's talk a little bit about really ethically representing children. What would be if you just could think of 3 things that you could do to ensure that you ethically represent a child? What would they be?
I think it's very important from the start of representation to set out very clearly your role and the child's role within that representation, regardless of if my child is 10 or 17, almost 18. I like to sit down and in age-appropriate language, set forth what I am hoping to accomplish, make sure that's in line with what the child is hoping to get out of this representation, and make sure that we understand each other's responsibilities to one another, and that I am working, for the child's best interest, because many of these children, we were talking about this before the panel started, they come from cultural situations in which they have never been asked, what do you want? What do you think? Do you like this? Do you not like this? They've always been told what will happen to them. And so it's a very foreign concept to sit down and have this kind of collaboration with an adult in particular, where they have a say in something. So I think it's really important in age-appropriate language, and sometimes this requires multiple meetings with the child, because believe it or not, traumatized children just don't open up to you within an hour's time and in a consultation and tell you everything that's happened and what brought them here and what they hope for the future. It requires several meetings. It requires informal meetings. A lot of times I'll just talk to kids about like soccer for 20 minutes or so to get them to open up. And it also requires some language competency a lot of times when you're working with immigrants. I don't speak every single language that my clients necessarily speak. I represent a lot of Guatemalan children who speak an indigenous language first and Spanish second. And so maybe I call a language line, or I get someone from the consulate to assist, so that the child is more able to open up and express himself or herself, because it's very difficult in a second language to even be able to start to open up. So I think those are all, you said one or two things, I think I said 10, but those are all things to consider.
Other pointers?
I would just add that I think it's very important to investigate as thoroughly as you can the extended family network and what's happening there, and try to get a feel for how that informs your judgment on the best interests of the child.
And I'm going to approach it in a little different direction, because we fought so hard for this in juvenile court. A child is entitled to a direct attorney in juvenile court now. There are some lawyers and judges who hate that because they think that the child should only have a guardian ad litem who is best interest. So I think ethically, one of the most important things is that I represent what this client wants. But, and we talked about this beforehand, you know, in juvenile, we tell ourselves that we're not attorneys and counselors at law, we're counselors at law and attorneys, because we do so much counseling and hand-holding and social working. But my job is also to counsel my client on my client's options as to what may be in my client's best interest. The easiest example is I represent an adult criminal. They've got him on tape, his DNA. If we go to trial, he's going to lose and get life in prison. They come at me with a deal of 15 years or 20 years. We wish, but you know, they come at me with this deal. So my client's like, no, I want to go to trial. I'm not gonna be like, okay, we're going to trial. No, I'm going to counsel the client. I'm going to say, here's the deal. Here's, you know, all the options. At the end of the day, if he still wants to go to trial, it is my legal obligation to argue for that. So when you represent a child in juvenile court on a petition for dependency that, you know, will end in SIJS status, it doesn't matter if my client wants to go back to Guatemala. That's ultimately what I have to argue, even if I personally believe it's not in his best interest. And if I don't believe it's in his best interest, then I am obligated to file a motion to have a guardian ad litem appointed, who will then argue to the court the child's best interests. So it's kind of one of those quagmires that we're in with this new law, but
It's still exciting.
yeah, it's
I
very
want
exciting.
to talk my personal number one rule that I tell every new attorney in our office. I sit them down, and they're all fresh-faced and excited, and I say, clients lie. It's true. They lie. They lie because they mean to lie. They lie because they don't mean to lie. They lie because they think you wanted to hear that side of the story. They lie because they believe that story to be true. They lie because that's how they remember it. I mean, they just lie. So you need to be very pragmatic in your representation, and don't be gullible as you're passionate. And I guess that's my struggle, and I've had a renewed vigor meeting the Honorable Judge, because I was feeling really worn down this week with the job we do and the timelines and the situation, and I was feeling like I was losing my spark. I know you can't believe that. So how do you guys keep your passion for this kind of work and still stay focused and edgy. And I know y'all are, so give me something from that.
Red wine. No, and actually, I want to make a very quick point. If you all decide to represent children or are already representing children, there's a book by Julie Kensington, and it's 3 women who are children linguists and wrote this book. I have been practicing with juveniles for 14 years. I went and I saw her last summer, and I was like, oh my God, I've totally been talking to children wrong, even though I've taken like 8 million how to interview a child classes. So if you do work with, I think it's like $10.99 from the ABA. But you know, it's funny because I came from the Georgia Parent Attorneys Committee training this morning, and as president, I decided that we would have a mantra, and it's a very long story, but part of our mantra is defy gravity. And how we see it in juvenile is that, you know, there's all these rules, there's all these things, and, you know, there's this big Oz person who's always fighting us. It's always a fight every day. It's like, just nothing, you know, can nothing can be easy, which one of our judges who passed used to tell us all the time. And so whenever I do hit that block, first of all, have integrity to yourself. Believing that you can work another 2 hours and you'll get as much done is not going to get you as much done. And I had a lot of therapy and spent a lot of money to learn that when I need a break, I need to take a break. Because if I don't, I'm just not going to be as productive as if I had. And I've followed that for some months now, and I'm in a totally different place. But, you know, and also have something of inspirational. You know, if I'm getting down, I'll turn up the wicked defy gravity. I'll be like, I'm gonna go get him. You know, it's like Rocky. You gotta have your Rocky song, you know. And venting with friends and family, except my husband, who hates hearing about what I do because it just makes him upset and cry. Well, not really cry, but want to cry. So that's really, and red wine, I'm serious about that. I've got the girls coming over for wine night in a couple hours, so. But not if you're an alcoholic or have a tendency.
Nice to say.
So please don't take that. You know, drinking's not
Okay,
necessarily
that's
good.
enough to me. Go ahead, Jessica.
Yeah, literally.
I'll piggyback on what she said. As far as having like a great group of colleagues or mentors, as Rebecca mentioned, she and I are in constant communication, and sometimes it's just nice to hear each other's war stories because you're like, it's not just me, you know, and there's other people fighting the same fight, and having great coworkers to vent to, and remind yourself of your successes. Sometimes I personally fall in the challenge of only thinking about the cases I'm struggling on, or I'm getting pushed back on, or this judge is, you know, saying really prejudicial things in my opinion, or this judge is giving me 2 days to file an asylum application, and how in the world am I going to do that? But it's nice to remind myself of this client who I served who's now graduated from high school. Or, you know, a few months ago I had a grandmother bring in, he was my 2-year-old client, he's now 3 and a half, and he has special immigrant juvenile status, just to come and say hi because he became really like connected to our receptionist, the people in our office, wearing a little suit and just saying thanks again, you know, and like those sorts of moments, sometimes you have to like stop and remind yourself like, I'm having a hard time here, I might not be able to win this case, but I've helped several other people, and remind yourself of the good you do too, not just the struggles.
I'm just inspired listening to all of the work that you do, and I think that it's the immigration bar in Atlanta I've found is just incredibly helpful to each other, and would be helpful to you for anyone who's trying to assist with this. But I think just in terms of what inspires me from this is renewed efforts, continual efforts for legal change, political change, in ways that address, at least try to make some sense, make something easier here for these children.
Absolutely.
And I think that listening to Jessica and the professor and Rebecca, I'm like, whatever. Y'all have a firm, you have colleagues, you have coworkers, you have an office. I'm a solo practitioner and have been, and my office is my study at my home because I'm always in court. But I think that it's important for solo practitioners that you can have that camaraderie if you join things like the immigration bar and listservs and things like this. We have several different juvenile listservs where it's like, hey, firm, it's just attorneys that represent parents or just attorneys that represent children. And in my talk this morning with parents attorneys, you're not alone, even if you're a solo practitioner. And I think that is really important. I also, one thing, and I'll stop, is we also have, in my office, I have a board of all the families that I've reunified or I've gotten together. And I have them send me a picture, and that for me is huge.
And kind of on that note, I guess my one pointer then would also be just to celebrate your victories. Celebrate the big ones, celebrate the little ones. We have a bell in our office, that's a hangover from Catholic Charities. And I mean, I forget what we were ringing the bell about the other day, a relatively teeny weeny little issue. I'm like, ring that bell. Go ring that bell, because it was a little issue, but it was a substantial issue to the end goal. So I think it's really important that, you do all this. Ring the bell every day, because especially with children, whatever you do to touch that child is literally life-changing. So be the force, go be the change you want to be, and be passionate and have good groups of people and just do what it takes. Have confidence, get the skills you need, and make the difference. Is there any questions or anything that you want to talk about? There's 2 microphones back there, so I would ask if you do have a question, please go to the microphone and tell us who the question's addressed to, and please ask questions. We really want to help. Would you mind going to the microphone, sir, please? I think they want to record it. And I could hear you. You do talk loud.
Hi. I heard Jessica talking about one parent, both parents. This is something new to my office. I'm noticing an awful lot of children coming in, and we want to help them. We've had some success in some of the counties far away that they don't really understand what this dependency order is. Are you guys having success when you have a child from Guatemala that leaves the mom and then comes to the dad in Georgia as far as the dependency? I'm wondering if there's success with that, or if they come here to stay with their uncle. I understand going through and becoming a foster child seems to be an easier case if they're not with a relative, but what about the other relatives? Is there any success with those?
I mean, I would say that the Georgia Juvenile Code is pretty clear that you're not in a dependent state if you're with a parent who's able to care for you, right? So, I mean,
Absolutely.
Being with a parent is not necessarily the end of the inquiry, because sometimes there are parents who aren't meeting the child's needs, right? But if you're living with dad is feeding you, you have a bed, you're going to school, all those sorts of things, I think that's where an ethical issue actually does come up. And we're seeing this a lot in immigration court. Rebecca and I were actually at a meeting yesterday with DHS attorneys who were complaining about this very issue, where we'll even hear attorneys on the record say, oh, well, he was with dad was fine, whatever, but we're moving him to uncle so we can seek special immigrant juvenile status. And just to say that on the record itself is pretty shocking, but it's also not necessarily the ethical thing. You might be getting that child's status, and that's, a positive outcome on the one hand, but I mean, at the other hand, you're separating them from the father, who might be a good caretaker. One thing to note, too, is if you get SIJ status and you get your green card, and even if you become a citizen eventually, you can't petition for those parents in the future. That's cut off. Ever, because that's kind of their punishment, right, for abuse, abandonment, or neglect. And so maybe on the one hand you think you're serving your client for this need, but on the grand picture, is that really in this child's best interest? And is that in line with the spirit of special immigrant juvenile status?
I think that's the bigger issue, and we talk about this a lot. When do we meet a child who is just desperate to be stable here, to have status, to go to school, but they're living with dad? And, dad's doing what she says. He's feeding them. He's sending them to school. And I hate that they're going to be undocumented at 18 and removable, but I don't want to diminish my reputation, the spirit and the spirit of the law for SIJS, or the work that we've done over the past 10 years with the judges, with the trial attorneys, with DHS, to let them know that we bring credible cases. So it's a struggle. Seek advice, seek people's opinion. Go where your heart leads you. But I guess for Jessica and I would guess Catholic Charities, yes, we wouldn't we wouldn't attempt a one-parent SIJ because we don't feel it meets the Georgia code.
Yeah, and I'm playing devil's advocate because here's my problem. When we have a child who is alleged to be dependent, living with mom and dad in Georgia, they're both Georgia citizens or United States citizens, and it's deprived, or the parents aren't married, and we just had this issue come up. It's called the one-parent doctrine, whether it's truly in Georgia. There's no law on it, but they enact it. So basically what happens to all of our fathers who are not legal fathers, department removes the kid, finds them dependent because they're not legal. So if you do think it's a situation in good faith where this child could benefit from that, then I think very much you can make the argument, because the first step of one of the first conditions of dependency is whether the child has legal guardian. So I have noticed if the parents weren't married, then technically he's biologically father, but that father has no legal right to enroll him in school or get him health care. So
and I would agree with that on 2 points. Number one is because the service is involved. So the service, or the department, has already deprived that child. So I feel very comfortable in that situation, and I think it's fact dependent and case dependent. So if the dad is truly not the legal father, a responsible legal father would legitimize. If dad refuses for some reason, then I think that's your ethical question and path. We have another question?
Mine's kind of a follow-up to that. So if you're a child fleeing some horrible situation in Guatemala or Honduras, and you come here to reunite with a parent, is there any recourse for you at all, or are you automatically going to be sent back?
I mean,
Well, first of all, define sent back.
Sent back to Guatemala or Honduras?
Physically?
Is there any path to remaining in this country if you come to Georgia to reunite with a parent?
yeah, I mean, it just won't be special immigrant juvenile status, right? There's potential
There's
with
asylum.
There's, if the parent has been the victim of a crime, a child can benefit as a U derivative. There's trafficking visas. It's just your inquiry is going to be a little broader then. It's not going to be limited to, can we go the dependency route with the state juvenile court? And a lot of times in those cases, if all of those things fail too, you might ask for just prosecutorial discretion with the Department of Homeland Security attorney. If there's great equities as to why this child shouldn't be sent back, the parents are here maybe with temporary protected status. This is a fact pattern I'm seeing a lot lately, is mom or dad or both might have TPS that doesn't allow for derivative benefits for the child, but if they go home, they lose that benefit and there's horrible conditions in the home. You make all those equity arguments and for that child to have the case kind of closed against them.
But even the kids who are receiving those removal orders kind of bring it full circle back to the child who's given the second opportunity to bring an attorney and either did or didn't, and there's no relief or can't get the relief done in time, and they get a removal order. The thing that I just keep stalling on is nobody's physically removing that child from this country. So guess what? Those 89,000 kids that people don't want here, they're staying. It's just now they're staying with this removal order that's prohibiting them today and in the future from stabilizing. So if this kid's a 2-year-old, like we have plenty of 2-year-old clients, I'm like, we got 16 years to figure it out before the government then are able, under the laws as they stand now, to physically remove that child. But maybe back and forth. But if the kid's 17, that's a more crucial decision than if they have an active outstanding removal order. So the system's broken. The ethical questions are everywhere. Just every day, do the very best you possibly can. Other questions? All right, well, Silas has asked me to tell you that lunch is going to be outside. not outside the building, it's too cold, outside right here. So please go ahead and grab a lunch and come back in right away, though, because there's more interesting people to hear after this. And thank you so much for this opportunity, for the time, for my panel here. What amazing experts.
The preceding program is copyrighted by Emory University.